a call. Yes. Please, Wes.
Adjournment, page 1, serial number 1. Page 2, serial number 2 to 4.
My lords, serial number 3, my lords, if I may request my lords to have it tomorrow, my lords. Personal inconvenience, my lords. I've informed the other side, my lords. I've informed my learned friend. Tomorrow, my lords.
At the request of Lord Counsel for the petition, list this matter on Friday.
Grateful, my lords. God bless.
Yes.
Page number tomorrow, senior counsel is ready. Senior counsel is ready.
Which case?
Serial number 4, my lord.
Oh.
The respondent, my lord, kindly have it tomorrow, my lord.
Tomorrow. At the request of Lord Counsel for the petitioner. Petitioner or respondent?
Respondent.
Respondent. Yes.
Page number 4. Serial number 6, 7. Page number.
Serial number 7. This is a case, my lord, where your lordships had heard it. Want some time, my lord, because last time also I made a representation that it may not be possible within third. I'll have to take instructions. It has been. It has been put up.
Have you informed the other
Yes,
side?
I have informed the OL also.
My lords, I am for the petitioner in the matter. I have not received any information
No,
regarding
I have
this.
not told. I have told the OL also. That,
No, they are,
Another co-respondent, what is the point of
they are
it?
they are the ones,
Yes,
they are
they
the
are
ones
the
who are
petitioner.
contesting it.
I did not. Lord, I did not inform them. Now that she is already present before your lordships. And the last date itself, I requested your lordships, my lord, that it may not be possible for me to take instructions by third.
List this matter on 3rd of March, on 4th of March as part heard.
Please.
Yes.
Page number
The
5.
request of Lord Counsel for the respondent.
Please.
Yes.
Page number 5. Serial number 8 and 9.
And by the time the necessary application, if the necessary application is not filed, orders will be passed.
Lord, I
based on
have
the-
filed few documents before your lordships, even prior to considering that also.
No, I'm saying as per the arrangement that day.
Alright.
Application is not filed based on the material available on record. Appropriate orders will be passed. Yes.
Page number 5, serial number 8 and 9. Page 6, 10, 11. Page number 7, 12 to 14. Page number 8, 15 to 18. Page number 9, 19. Page number 10, 20 to 23.
My lord, I appear for the serial number 22, my lord, I appear for the respondent. I need 1 week time to file the objection.
for the petitioner, madam. It can be adjourned.
Vakalatali, the company name is not there. And
Request of Lord Counsel for the respondent list this matter on 18th of March. Yes.
Serial number 23, my lord. I appear for petitioner, my lord.
What is the number she said now?
22.
22, my lord.
Yours is?
23. This matter is settled, my lord. We'll file the report settlement.
How many times? The same representation? So why is it listing every time? Will not extend interim order and will adjourn it. This is not, what finally? At least this has come up how many times before this court? This is matter on 11th of March. Is submitted that the parties have read the settlement. Yes.
Page
Well,
number
serial number 24. I appear for petitioner's counsel. He is not keeping well, my lord. He is not keeping well. He is in
We
a.
submitted that the land counsel for the petitioner is not keeping well. Is this matter on 12th of March? Yes.
Much.
Page number 12. Serial number 30 to 36. Page
Serial number 35, my lord. The
Yes.
matter has become infructuous. It's been
30?
5 for the
Suit is
petitioner.
withdrawn.
No, my
Land
lord, they and 39 rule 1 and 2 application has been rejected, on which I have filed an MFA. So this writ petition doesn't survive for consideration.
Then counsel appearing for the petitioner submits that the application, the against order pass, grant of injunction.
They had not granted the injunctions.
As injunction was not granted, he has already filed an MFA.
Only notice was issued. The
MFA
this
and as such this petition does not survive for consideration. Accordingly dismissed as infructuous. Yes.
page
much
number
obliged.
13, 37 to 44.
My lordship, serial number 41, I am filing memo for withdrawal. That is
40?
settled in out of the court.
40?
41. It is settled
Then
in.
a memo is filed stating that the parties have settled the matter out of court, hence they want to withdraw this writ petition accordingly. The memo is taken on record and the petition is permitted to withdraw the writ petition.
Your Lordship, serial number 43, Your Lordship. For the respondent, Your Lordship.
40?
43, Your Lordship.
Hmm.
I'm for the respondent, Your Lordship. I seek a week's accommodation, Your Lordship, in this matter. Seniors out of the station, Your Lordship.
Appear for whom in 40?
For the respondent, Your Lordship.
1 minute. Yes.
For the respondent, Your Lordship.
Why the court is not audible to you? Yes.
Yeah, for the respondent, I appear for the respondent, Your Lordship. I seek a week's accommodation. Seniors out of station, Your Lordship. I may be granted.
Madam, somebody is submitting here in the open court. Please you wait and
Apologies, I couldn't hear that, Your Lordship. Apologies.
What happened to the respondent? Ah. Have you informed the other side? Informed or not informed? No. Please come when the matter reaches. Yes, what is the serial number?
She is submitting 43.
Yes, 43.
For the respondent, Your Lordship.
What about the petitioner? Have you informed them?
Your Lordship, no, I have not informed the respondent.
Then wait. Yes, next.
Page number,
Yes.
page number 14, serial number 45 to 49.
46.
45, my lord.
46.
Mm.
And for the petitioner,
Mm.
respondent is not represented by anybody. It may be had on the 12th of this month, what I believe. 12th.
Lisa's matter on 19th of February at the request of one counsel the petitioner. Yes, next.
Serial number 45, my lord. I am
Yes.
contesting election, my lord. Please kindly pose this matter on 17. Today is the nomination period, my lord, with regard.
Is this matter on 12th of March? Yes.
Interim order may kindly be extended.
Look at it if it is there, extend. Yes, next.
Page number 15, serial number 50 to 52.
Number 52, Mala. For the respondent. Kindly apply.
Can be adjourned.
Yeah, the 12th of the ended date.
Huh? This is
After 12th, after
This is
12th,
matter on 4th of March at the request of learned counsel for the petitioner,
please, respondent.
respondent. Interim order, if, look at it, if it is there, extend.
Please, that's all.
Yes, call the list.
Page 1, corporate matter, serial number 1.
Your Honor.
For petitioner.
I just wanted to make a request. The judgment was pronounced on
No, that you
29.
cannot make. You have an advocate on record. If at all something has to be made, he will make. Not you. You are not a party in person. Yes, next.
Serial number 1, I am here for the petitioner, please, your lordships.
Yes.
Lordships, in this case, your lordships, in spite of my best efforts, I am unable to get in touch with the petitioners. I have also sent him the reminder. If your lordships would kindly grant me 2 weeks accommodation, I shall file my retirement after giving the service of notice, please, your lordship.
But I have serious objections to this.
What instructions you require at this stage?
Your lordship, he wants me to either go ahead with the matter or to retire from the case. He wanted me, I had asked him to appear before the trial court as well. He has not appeared. In spite of my repeated reminder, he is not.
He has not taken no objection from you.
No, please, your
And
lordship.
then in that case, we'll hear it on the merits of it.
Please, your lordship.
Yes,
Lordship, this is a execution petition, please, your lordship.
yes.
The execution petition has been filed challenging the order of attachment of immovable property that has been passed. Now, if your lordships may have to kindly see, this was a suit for recovery which was filed in Andhra Pradesh. They have got a ex parte judgment and decree against me. I am residing here in Bangalore. The property to which they have sought for attachment is also in Bangalore. But now there, your lordship, I am not at all aware about the proceeding, what has happened in Andhra Pradesh. I have filed an application for recalling the said order. Miscellaneous petition is also been pending. Thereby, your lordship, I had filed an application seeking for a certain amount of time for me to make an arrangement to appear before the Andhra court by making a necessary application to recall the or set aside the ex parte order. In the meanwhile, your lordship, the execution petition has been filed here and the said execution petition has been transferred from Andhra to Bangalore. and they have issued an attachment notice. That order has been challenged before your lordships, please, your lordship.
What happened? What happened to that ex parte order? Which
They
year is
have-
that petition?
There, your lordship.
2019, we are in 2025.
Yes, please. But your lordship, there I am not appearing, your lordship. Some other counsel is appearing and is making his
What has
best
happened to
efforts.
that?
Now, my lord, my submission is they have not filed any necessary application for order 9 rule 13 to
To
set aside
set
the
aside
ex
that
parte
order.
order. That was my categorical submission that I made.
Let's
for the
let's look at the impugned order.
Your
Page
lordship
number,
gets it. Your lordship gets it at page number 16, please, your lordship.
page number.
16.
What is there in 16?
Handwritten order, please, your lordship. Heard on IA, petitioners present issue warrant of attachment of movable property, scheduled property if complied. Order dated 16/11/2017, please, your lordship.
Heard on IA. Where is the need copy for this?
Your lordship gets it in
To warrant for attachment of removable property.
page number 38, if your lordship could kindly, please.
By 1612. There's an interim order by this court.
Yes, please, your lordship.
It has not been extended.
It is been, even on the last hearing date, it has been extended, please.
Why would it be extended when you're not present before
Your
the
lordship,
court?
it was in list number 2. Well, it is my mistake, but then your lordship,
It is not.
May I make a
On
submission?
29/1/2025, as there is no representation on behalf of the petitioner, the matter was directed to be listed and the caption for dismissal on 31. On 31/2025, today there is no representation. Heard the counsel for the respondent, post this matter. It is not adjourned on the last occasion.
Make a
Yes,
submission.
please come.
It itself is not made amendment, they have not challenged the ex parte judgment and decree. For the last 6 years, my lord, they have ensured that I do not recover my money. Now, even without getting the right order from the jurisdictional Budwell Court of Andhra Pradesh, incorrect submission is made before the executing court at Bangalore.
Agreed with the order dated 16,
11/2017, please, your lordship.
11 or 12?
16/11/2017.
2017. Whereby the court had ordered for warrant, had issued a warrant for attachment of immovable properties. The petitioner, judgment debtor is before this court. The facts of the case are the respondent herein had filed OS number 118 of 2016 for recovery of money before the additional senior civil judge, Rajampet, Andhra Pradesh. In that, an ex parte judgment and decree was passed on 31/8/2017,
No, no.
directing an ex parte judgment and decree was passed on 31/8/2017, whereby the defendant was directed to pay an amount of rupees 6,24,000. 24,000. Thereafter, the execution petition is filed before the additional senior civil judge court Rajampet and sought for transfer of the said decree as the petitioner is residing at Bangalore and the scheduled property comes within the jurisdiction of the City Civil Court, Bangalore. The court at Rajampet has transferred the execution petition from Rajampet to Bangalore. It is a case of the judgment debtor that he has no knowledge about the judgment and decree that is passed by the courts at Andhra Pradesh. It is a case that the petitioner has not, the judgment debtor has no financial transaction with the decree holder. And he came to know about the decree only when he received the notice. It is stated that the court by order impugned has issued the warrant of attachment without even issuing notice to the petitioner. On 16/12/2018, The decree holder has executed the attachment of movable order and has attached the property belonging to the petitioner. Then he has appeared before the executing court and sought time for filing objections. The land counsel appearing for the petitioner judgment debtor submits that the court ought to have granted a reasonable time and ought not to have executed the warrant, ought not to have attached the mobile, ought not to have passed attachment order. When an order is, when the judgment and decree is an ex parte decree. As the petitioner is a resident of Bangalore, is not aware of any of the pending proceedings before the courts at Andhra Pradesh. It is submitted that the court, without considering all these aspects, has issued the attachment warrant. And the same is liable to be set aside, giving reasonable time to the decree judgment debtor to contest the matter before the courts at Andhra Pradesh. Next paragraph. Land counsel appearing for the respondent decree holder submits that a judgment and decree was passed on 31/8/2017. Even till now, the decree holder could not realize the fruits of the decree. He submits that so far, no steps have been taken by the judgment debtor to file an application before the court at courts at Andhra Pradesh seeking to set aside the ex parte judgment and decree. And instead of going before the court, the petitioner has come before this court and obtained a stay of all further proceedings. It is submitted that the writ petition is not maintainable and the same is liable to be dismissed. Next paragraph. Having heard the land counsel on either side, there is the material on record. The petitioner is aware of a judgment and decree, an ex parte judgment and decree, according to the petitioner, when the EP is filed, when the attachment order is passed by the court, that is in the year 2019. Land counsel for the respondent decree holder submits that even till now, they have not filed any application to set aside the ex parte judgment and decree. When an ex parte judgment and decree is passed by the court, the proper course that is available to the party is to file an application for the very same, to file an application to set aside the such judgment and decree. Admittedly, in this case, no such exercise is done by the court, done by the petitioner decree or judgment debtor, and it could successfully stall the proceedings and the decree holder could not realize, could not execute the decree and from 2017 in view of the, from 2018 in view of the stay orders passed by this court, the considered opinion of this court, the remedy that is available to the petitioner is not to approach this court, but to approach the court which has passed a judgment and ex parte judgment and decree. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed.
Obliged.
I oblige.
Case number 2.
Lordship appearing for the petitioner in this case.
What has happened?
The last occasion, your lordship had said whether she's, the mother is okay for the visitation to be granted to the father in the presence of the grandmother, who is also before the court. They said they would get back to the court on that.
Yes, Mr. Counsel.
Your Lordship, supervised visitation is one thing which I have got the instruction due to reasons which are this. Child is first of all traumatized. The grandmother as well as the father scolds her. Father has scolded, which is there in the pleadings as well as the statement of objections when she has revealed the things in the court. And the grandmother also scolds her. So these are the two things where supervised visitation should be there. The next thing is why it should not be unsupervised, because last time your lordship has ordered on 18/5/2024 an unsupervised visitation. The respondent has executed that visitation right. At the same time, when she was in the roller skates, when he got a call, he has just left her and took the call, and she fallen down with having back injury.
What is her age?
Her age is 11. Your lordship, this roller skates is not a small one, a bigger one, which is there in the malls. And next occasion on 23/6/2024 also, as per this honorable court's order, he has taken her unsupervised visitation, and at that occasion also, he has force-fed the food which she didn't want, and she was food poisoned and in the hospital. So these 3 or 4 occasions, even the previous time when the court has given, he has not systematically exercised the visitation rights, where he has taken to Jay's Brewing Company, which is a pub. And scolding the child as well as the trust deficit will be making the child in more trauma if it is not a supervised visitation, your lordship. And Saturdays, your lordship, 11 to 1, and Sunday 2 to 3:30, your lordship. Alternate weekends with supervised visitation.
Sunday, who will supervise?
Sunday, mother will be there.
Yes.
But in fact,
Oh, what is the impugned order? Where is the impugned order?
because in fact, your lordship. will,
No, the impugned order is which page?
the impugned order is at this is his petition, so it is at
Your lordship can see at page number 69.
53 minutes. And next H,
It starts with 63.
and it's H. Look, this is an order. What has happened is in 2023, there was an order passed by the family court where 50% vacation was granted to the father along with 2 overnight weekends.
Come to the operative portion at page 72.
Please.
Oh, this is already worked out. Number 1. The respondent is entitled for the visitation rights of his minor daughter from 24/12/2022 to 26/12/2022. Page number 72.
72, yes, Milas.
That's over now.
That's 50% vacation is over, Milas.
But Christmas, that part is over. Then the
The
petitioner,
Christmas part is over. This was another order, Milas. Christmas part was another order.
where is that?
Let's, that I think, your lordship will get it. Page number 30, Milas, ink page 30. That is annexed Milas.
Page number 31, your lordship can see.
Annexed A is the impugned order. Page number 30, if I may just,
So that vacation is over.
vacation
So
is over.
on first and fourth
First and fourth,
Saturday,
that's
with the
right.
following Sundays,
Yes,
mother shall facilitate the respondent to have the interim custody of the child. The respondent shall pick up the child from the home of petitioner at her residence. Please come.
the respondent's mother is also present before the court.
Agreed with the orders passed in GNWC number, IA number 3, in GNWC number 29 of 2020 dated 21st April 2022. The mother is before this court by order impugned the court had granted second half of the summer vacation 2022. And other than that, also directed the father can have the interim custody of the child on first and fourth Saturday with the following Sundays. It is also observed that the mother shall facilitate the respondent in all respects to have the interim custody of the child. The father can pick up the child from the home of the mother and shall hand over the custody of the child to the mother at her residence. During the interim custody of the child, the father shall take utmost care of the child in all respects. The respondent shall not, the father shall not ill advise the child about the mother or her family members, and he shall not criticize the mother or her family members in the presence of this child. On 17/1/2023, an interim order was granted as prayed for. And that interim order extended from time to time till, that interim order was extended on 14/2/2023 till the next date of hearing. On 2/4/2024, when the matter came up before this court had directed the minor, directed the mother to bring the minor before this court in the chambers at 2 p.m. And thereafter, on their request, the matter was adjourned to 19/4/2024. Then, thereafter, it came up before the court on 23/4/2024. This court on that day had granted visitation to the daughter along with the mother on 27/4/2024, 28/4/2024, 4/5/2024, 5/5/2024, 10/5/2024, 11/5/2024, and 12/5/2024 at any public place, Phoenix Mall, or park between 3 p.m. to 8 p.m. on Saturdays and between 3 p.m. to 9 p.m. on Sundays at any other place which is to the liking of the girl. Then court has also observed that on 18/5/2024, 19/5/2024, 25/5/2024, 26/5/2024, 1/6/2024, and 2/6/2024, the father can exercise the visitation rights without the mother at any public place between 3 p.m. to 6 p.m. And the father shall pick up and drop the child. And directed the matter to be listed on 6/6/2024 as part heard. And by the time the party shall bring to the notice of the court what transpired between them, and based on that, the further orders will be passed. On 19/6/2024, father, grandmother, mother, and daughter are before the court. The court had recorded that it is submitted that the visitation as ordered by the court on 23/4/2024 went on well. Considering that, the court again has passed orders permitting the father to exercise the visitation on 23/6/2024, 7/7/2024, 14/7/2024, 21/7/2024, 28/7/2024, 4/8/2024, on 10/8/2024 between 12:30 to 8 p.m. The order dated 22/8/2024 this court had, as per the order, it reveals that both the husband, wife, and child, along with their counsels, were present in the chambers. The court interacted first with the child and then with the mother and the father. Considering the submission of the parties, the court has again permitted the father to exercise the visitation. When the matter came up on 6/11/2024, the submission is made on behalf of the counsel appearing for the mother that the daughter is not comfortable to meet the father. As such, no order shall be passed directing the daughter to meet the father. The mother submitted before the court that she cannot leave the child with the father. The court recorded that inappropriate touch is not about touching the private parts, but when the girl is not liking the father to touch her, that is also an inappropriate touch, and she cannot let the daughter to be with the father.
Oh, that's mad. Earlier to that, your lordship has interacted and the child says she has absolutely no problem to stay with the father during the same 6/11 order. The third,
So
fourth.
that is what I have recorded is about earlier, that I've already recorded in the order.
Your lordship, putting her in the lap also has been pointed by the
That I'm
mother.
recording, she
Please,
submits
your
that. He made her to sit on the lap and she cannot permit the father to meet the child alone. It was also recorded that it is a submission of the counsel appearing for the father that she cannot stay with the father overnight, but she is comfortable during the daytime. And it is the complaint that the mother is not letting the father and child to develop the bonding. And what are the things that the mother has referred to? The father has never done all those. Then this court has recorded that there is a lot of reluctance from the mother in the light of the differences between the mother and the father. This court has also observed that this is not the manner in which the mother has to deal with the situation. If the daughter is not comfortable for any reason with the father, the mother should look at the means and ways to deal with the situation, but she cannot show the aggression and simply say, daughter is not interested. And it is also observed that this court had a wrong interaction with the girl. The girl has no specific reason to say why she is not comfortable, except stating that she is not comfortable. Earlier, it was projected before the court that the father was inappropriately touching the daughter. Then on interaction with the girl, the court understood that as stated by the counsel or by the mother, that is not the behavior of the father. The court also do not see any kind of efforts from the side of mother to see that the bonding develops between the father and the daughter. And the court also observed that the mother is not able to realize that this kind of hatred or ill feeling towards the father is not good for the daughter. And the mother cannot say that she will not let the daughter to spend time with the father. And the mother has submitted before the court that if at all visitation has to be granted, it has to be before the family court. And this court has also expressed that mother cannot dictate the terms to the court. And things will not be done as how the mother wants it. Orders will be passed taking into consideration the welfare of the minor child, where this court is exercising the parent patriarch jurisdiction. The court also came to the conclusion that the manner in which the things are going on, they are not in the interest of the minor. And if the child grows up in this manner, she can definitely not evolve as a good human being. And again, on that day, this court had granted the visitation before the mediation center. And in the presence of a counselor. And they were directed to directed to place a report before this court. Another order was passed on 20/11/2024, where observed that if the child counselor is not present, the director shall be present at the time of conciliation. And on 12/12/2024, again directed them to appear before the Bangalore Mediation Center. Thereafter, the report is placed before this court, wherein the report of the counselor reveals that the daughter is sharing a good bonding with the father, with the mother, but the same is not there with the father. On 21st December, the daughter met the father in front of the counselor, and she was much better in responding than her last meeting. She and her dad interacted and did some crossword puzzle and viewed some pictures and videos of earlier visits to her father's place. And the counselor had appreciated her and kept talking to interact and respond to the father. Then when she appeared, when she interacted with the father on 23rd December, she was reluctant, not at all interested to talk or even look at the father. She has complained to her mother that she was forced to talk on 21st December. Though it was an urging from the end of the counselor, and the father was happy to just spend time with her. On that day, she put her head down, and when she was asked to see and talk, it is stated, she said that she do not want to spend the holidays like this in court. Very disheartened, the counselor, the report stated that it is very disheartening to see the child respond like that. Even then, she spent her time till 1 p.m. The third meeting was also spent as earlier one. As soon as she entered the room, she just put her head down and didn't respond to the call, to the counselor's call or the father's call. She didn't respond to any crossword games or videos or photos. Like it indicates that she was forcefully made to sit and talk. Later of the meetings were called off as the child was not well, and a winter vacation got over and the school resumed. The counselor had concluded saying that she was encouraging the father to have interaction with the mother concerning the daughter, but father is not comfortable for talking to mother, and vice versa. Child hesitation to visit her father during this phase is a multifaceted issue rooted in emotional, psychological, and environmental factors. Both parents can help ease the transition for child and preserve the relationship between her and father through open communication, emotional support, and a commitment to create a safe, stable environment which will be crucial in helping child overcome her visitation and adjust the changes brought on during the divorce procedure. The land counsel appearing for the mother submits that the petition can be disposed of by granting a supervised visitation in the mediation center between
Your Lordship, Saturday, uh, 11 to 1.
Saturday 10 to 1,
So, sorry, my Lord, 11 to 1.
11 to 1,
And Sunday 2 to 3:30.
and Sunday 2 to 3:30. It is submitted that if the girl is left alone, father will not be taking care of her. For that, he gives the instances stating that one day when the girl was playing or was doing what is that she's doing?
She was
Skating.
doing roller skates,
When she was
which is
skating,
a motorized one, Your
when
Lordship. It
the
is a big
father
one.
had received the call, he left the girl. She fell down and injured herself. On another occasion, when the girl didn't want to eat something, and he forcibly made her to eat, and thereafter she has developed
Food poisoning.
and it was a food poison,
And was in the hospital for
and
that.
she was in hospital. Bringing these instances to the notice of the court, he submits that unsupervised visitation is not in the interest of the minor. And if it is in the mediation center, it would be with the counselor. And when it's a holiday for the mediation center, then the mother would be present during the visitation. Next part, land counsel appearing for the respondent father submits that if, as the counselor report is very clear, that the girl who is comfortable on one day, immediately the next day, she is not comfortable and talking to the father. It is all because of as she has been influenced by the mother, she is reluctant to see the father. Land counsel also submits that in one of the orders, this court has considered and observed that the daughter stated that overnight she cannot go to the father, but she's comfortable during the daytime. And also the visitation went on well, and that was also reported before this court. It is submitted that as the disputes are pending between the father and the mother, and the girl is being influenced by and she's mirroring the emotions of the mother, and she's reluctant to see the father unless and until the exclusive visitation is the unsupervised visitation is given to the father. It would be very difficult for the daughter and the father to develop the bonding. Land counsel submits that whatever are the conditions that are imposed by the court, the father is ready to oblige. And even if the grandmother, if the visitation is granted in the presence of the grandmother, and she would be present whenever the father exercises the visitation. To that, land counsel appearing for the mother submits that the father, in fact, both the grandmother and the father had scolded the child when she revealed her unwillingness before the court. So even if the grandmother is there, it would not make.
Your
any-
Lordship, it was not the unwillingness, it was that Jay's brewing company, she has been taken when that
Stated
was.
that the father was consuming alcohol when the girl was with him. When that was brought to it was stated before the court. Both of them have scolded her. It is submitted that the visitation has to be supervised and as per the timings stated by them. Next, having heard the counsels on either side, there is the material on record. When this court had interacted with the girl and when the submissions were made, initially it was submitted that father was inappropriately touching her. As such, the girl was not interested to meet the father. Then on an interaction, when this court had asked the girl, what is that inappropriate touch she is referring to? She has stated before the court that she do not want the father to touch her. And it is stated that the mother stated that he's making her to sit on the lap. And what is not of girls liking is an inappropriate touch. On a couple of occasions, the visitation was reported to be that it was reported that the visitation went on well by both the parties. And on some occasions, they've stated about the father not taking care of the girl getting hurt, and also the father forcibly feeding the girl, which she do not want to eat, and which resulted in food poisoning. The girl is aged 11 years. In the earlier orders also, this court has specifically observed that the mother was reluctant and very aggressive while she was submitting before the court that there cannot be a visitation outside the mediation center. And in fact, the court has also observed that the mother cannot dictate terms to the court, and the things will not happen in the manner how she wants, but the court would be passing the orders which are in the interest of the minor. A perusal of the orders that were passed by this court earlier and also the report of the counselor reveals that the girl do not have a specific reason why she do not want to interact with the father. If a particular, when she said that she do not want she's comfortable during daytime, but not with the overnight custody, this court had accommodated that also. And what is her behavior one day, and then immediately the next day, there appears to be a change in her behavior without any valid reasons. It appears that because of the disputes and the differences between the mother and the father, the girl is identifying herself those as being is driven by the emotions of the mother. It is a duty of the mother to see that the girl is not affected by any of the differences between them, and she has to grow without all these inhibitions and without all this the emotional issues between the mother and the father. it's a duty of both the mother and father to keep the child away from their disputes, and let the girl live a comfortable and happy life, and also to have a comfortable and to have a happy childhood. The the way the mother wants the visitation to go on, it is definitely will not fetch any positive results by granting the visitation in that manner. If on every visitation before the mediation center, with all this, the consistent, as this court has observed the counselor's report, how it has, the mother has to advise the girl and to see that the father, the child develops a bonding with the father. The mother has to realize that the girl developing the bonding with the mother, with the father, is ultimately in the interest of the daughter. And these ill feelings towards the father will have a long lasting effect on the girl and her future. This court do not see any great reason why the unsupervised visitation shall not be granted. The minor incidents, what has been referred to, cannot be a ground for this court not to grant the unsupervised visitation to the father. The trial court, the family court, by order impugned, had granted second half of the summer vacation 2022, as now that order is already worked out. As such, this court is not going into the said aspect. Then coming to the interim custody, the court has observed that the father shall have the interim custody of the child on first and fourth Saturday with the following Sundays. Considering the submission of the and counsels on either side, this court is inclined to modify the said order passed by the family court. And accordingly, this court is passing the following order. On every Saturday, the father can pick up the child from the mother's place at 10 o'clock and drop her back at 5 o'clock in the evening. Number two, the father shall ensure that at all times the girl is comfortable, and the mother shall encourage the girl to have a bonding with the father. 3, considering
Lordship, the child has got classes on Saturdays.
then let it be on Sunday. Sunday
2 classes are there.
at what time?
11:30 to 12:30 and 4 to 5.
What classes? 11:30, Saturday, Sunday, on all days she'll be studying. What is her
No.
age?
It is a music class, Your Lordship, and badminton class.
Let her accommodate accordingly. Father also has a right. Let it be
Your
on
Lordship, a
Sunday.
father who has abandoned by writing with his hand, I do not want any authority, control, custody over my daughter Aparna Pillai. when she was 5 years old, these all things will be there, your lordship, naturally.
On the merits of the matter, I've already heard you and I'm passing the order. No, when I'm passing the order, I'll not hear the arguments, Mr. Counsel. I'm passing an order now. Oh, yes, what did you write? If the father, girl is not comfortable in making her sit on the lap or touch her, let the father maintain the distance and keep the girl comfortable accordingly. The
Your
written
lordship,
instruction-
at the same time, she should not be scolded for revealing the things to court or such kind of.
No, if at all they are doing, they'll be unnecessarily, no. If it will be,
But never he has made.
an inference has to be, no. But one thing, even while interaction also, I told to your client, like, there is a way to deal with the things. It's not that, you be a father, whatever gives you happiness, you shouldn't do. That too in a strained relation of this nature.
Correct. May I just, never he has made the child. Because all the visitations that your lordship ordered in the chamber, my lords, the mother was present. Could never. And regarding, that's the skating, that was the only time. he
The mother was there at the corner only, your lordship.
Those are all the things we're not concerned with that.
Even that did,
About-
he never received any call.
No, when she fell down while doing
She did not
skating.
fall.
No, even that, or like,
Poisoning,
food poison
Yes,
and all,
yeah.
that's not the issue.
Correct.
But the thing is, like, if the girl is not comfortable, let her leave. You can't force your emotions on her.
Not it.
Let her keep her comfortable at all times. If he is not doing, then he'll be buying it at his own.
Definitely,
Please advise him.
definitely.
And it is not about always showing, exercising your authority, your power, your right.
He has never.
But it is like having the acceptance and taking her. And now, if the girl is with him, there is no different, there are no, the relation between the father and the mother are okay. These kind of things won't arise. Then you don't have to be so cautious. Under these circumstances, he has to be. He has to.
I think he's overcautious, my lord. I think that, in fact, she has told, the girl once said, why don't you take me to your house? For which he has told, no,
Your lordship, last time also I told it
I
was
heard it, I
to
heard it.
her
Anyway.
house, not to his house. It's twisted.
Yes, it's next. Huh? Post.
Your lordship, it is Saturdays.
Whatever you want, Saturday, Sunday. If you say Saturday, Saturday or Sunday.
Can I get 5 minutes?
2:30, you inform the court, it will be Saturday or Sunday.
Please,
According to
your
the
lord.
girl's convenience.
Please, your lordship.
Yes, next.
Oblige, your lordship.
Cell number
Yes.
3 and 4 urgent, cell number 5. Narendra S for petitioner, yes. Narendra.
Every day, what is this Passover in this matter? No, that's what I'm saying. Every day, if this, either he has or he has. Passover.
I requested tomorrow, my lord.
No, tomorrow. We'll do it. Every day we can't list the matters. 6. Next.
2:30, my lord.
For take the history of cases before mentioning.
You're not concerned. Somebody else is the advocate. Let him come. Yes, 6.
2:30, my lord.
2:30.
Please.
Yes.
Cell number 6,
Appear for the petition.
Yes.
Nanda Reddy PN for petitioner.
Let suit for recovery of money was filed.
Hmm.
Let the defendant appeared and filed his return statement. And of course, documents also marked. In the meanwhile, the compromise was entered into.
You are the
Plaintiff
in the suit.
suit.
Uh.
Suit was compromised and decree also done accordingly.
When was the compromise decree?
Hmm. to the district.
That refunded.
There's no
What
dispute.
Stamp duty.
Stamp duty similar to for the document, so it was unregistered document. It was written in the stamp paper of 100. That's how it was referred to the district registrar.
Let's see the order.
Page, annexure D, page 22 is the order. In view of the fact that exhibit P3 unregistered document styled as compromise agreement dated so and so, the defendant's side passed for impounding of the document by sending the same to the district registrar for due determination of stamp duty. It has been contended that exhibit P3 is found to be.
So order is dated 4/8/2018. Compromise decree is 17/6/2019.
Yes.
How can that order be questioned now?
No,
That is much prior to your compromise. This is sent. 4/7/2018 is the order. Compromise decree 17/6/2019. What is the relevancy between the two?
No, 17/6/2019, although mostly 18. It's a
Where
mistake.
is that order? Let's see.
No, annexure C is the compromise petition.
Page number.
Page number 16. A mistake, I think it is.
19 it is.
19 it is there.
No, even on it is not a mistake. Here also it is there 19. Have you seen at page number 16?
No, initially, of course, initially it was objected by the defendant at the time of filing the written statement and all.
No, once a compromise decree is passed, whatever are the orders that are passed, they have culminated into this compromise decree.
Yes, that is.
So where is the point of with this court deciding about that now?
No, that was page 29. That compromise was recorded on 17/6/2019 only.
Correct. And the order impugned which you are referring is of the year 4/8/2018.
No, 19 only. Page 30, you last may go to page 30. Page 30. That is the order passed by the trial court. Suit decreed as per the terms of the compromise petition. Compromise petition filed under 23 Rule 3 is allowed. Shall be part of the decree. Copy is sent to exhibit P3 to the district registrar. This is the order which I am challenging. Office to refund the court.
Which provision of the Karnataka Stamp Act?
Stamp Act.
Let's see.
That's also recorded.
Stamp Act. This which project? Look at it, pass off.
Cell number 7 adjourned, cell number 8. Yes,
Can it be
number
called tomorrow? I will examine that.
Tomorrow.
Tomorrow.
One day time.
Why?
File LR's application.
Non-taking of steps in respect of deceased R3. Give that order. This is on 6/12/2024.
My
We'll
lord,
discuss.
kindly pass over, my lord. Welcome.
What will happen if I pass over?
Comply, my lord.
Huh?
Courts of today comply.
How will you comply? You have to file. How will you file without you having it?
Kindly pass.
List this matter on 3/2/2025. By the time if appropriate application is not filed, the petition shall stand dismissed without further reference to the court. What remains now? We'll pass over, call it, we'll dismiss it against that who died. We'll dismiss it as abetted. Yes, next.
Serial number 9. Serial number 9,
You that?
Murali Babu, M for petitioner.
This is a writ petition of 2017. When the matter is listed before this court for orders, on 16/1/2025, an order is passed granting a week's time to comply with the office objections. If the office objections are not complied, the writ petition shall stand dismissed without further reference to the court. And also directed the petitioner to file an application for substituted service of notice within 10 days. If the application is not filed, both the petition shall stand dismissed without further reference to the court. Today, when the matter is called, there is no representation on behalf of, or else list this matter for dismissal. Tomorrow we'll pass this order. No representation, and the order passed by this court is not complied with. This is matter tomorrow for dismissal.
Serial number 10. And then from GR for petitioner.
Petitioner, my lord, I must, firstly, my lord, I'm asking a policy, my lord. My mother is not keeping well in previous state, my lord. Before that, I will not file in the memo, my lord. In course of the day, I will file the memo, my lord, for dispensation of the respondent number 5. My lords.
This is matter day tomorrow.
My lord, kindly fix the date on 6th, my lord. I am ready to order.
This is matter on 6th at the
Please.
request of friend counsel.
Please, man. Course of the day, I will file, man.
Yes.
Much okay.
Serial number 11. Serial number 11.
No representation for the petitioner. List this matter for dismissal. Counsel, the respondent is present. Next 12.
Tomorrow. Serial number 12.
Petitioner, my lord. Wait for some short accommodation to come.
A week's time is granted for doing the needful, or else the petition shall stand dismissed without further reference to the court.
13.
Petition in
P.
this case.
Rajaram.
Petition in this case, my lord, yes, filed a memo.
Have you
One more with that.
acknowledgement?
Acknowledgement, no, acknowledgement in the sense, my lord, I am the petitioner, my lord, now I came on record. And when he wants to retire, the other advocate, he wants to retire for that, he has filed a memo, it seems.
Oh, you already filed.
Yes, I came on
a-
record now, yes.
Rajaram.
Rajaram, please.
And then counsel, Mr. So-and-so has filed a memo for retirement. Already another counsel, Mr. T. Rajaram, is there on record.
Please.
Delete the name of, accordingly memo is taken on record and the petition is permitted, counsel so-and-so is permitted to retire. Then what about on merits?
I'm going, so tomorrow I'll make my submission. Today morning I was not there. And today morning I came. Tomorrow you will be kindly posted, I will make.
Look at it, you are for the petitioner or respondent?
Petition.
But cause list shows retirement filed by advocate for R1.
Okay, R1.
What is the name of the petitioner?
Petitioner is Jayam members.
Something is wrong with this. He is the advocate for respondent.
No, members.
Huh?
I'm sorry, but Lordship may kindly allow them to retire for this respondent.
How can you say that?
No, I cannot say anything about it.
Who appears for the respondent? Yes,
Shahid Fazil M.
no representation for the respondent. Leave that order. No representation for the respondent. List this matter on 18th of March.
18th of March.
Yes,
Serial
14.
number 14.
Representing the respondent number 1 my lord. I had already sent the copies to the other side. To RPID, thereafter I filed the from the statement.
Huh?
The objection statement I had filed after serving the notice to the, sorry.
What
copies,
statement?
To the respondent.
Statement of objection has been filed by them, my lords. Office objection is there that they have not served the copy, my lords.
They've already.
Yes, my lords. My lords, in this.
82 to itself, the complaints has been made.
Office has taken the objection that on the
Acknowledgement
statement
is
of
there.
objections, the copy is not served by the counsel for R1 to R5. Then counsel for the petitioner submits that they've already received
Yes, my
the
lord. Yes, my lord.
statement of objection.
Another submission, my lords. Petitioner number 2 is dead, my lords. Will find necessary.
Submitted that the petition number 2 is no more. What is that?
Submit ಮಾಡಿದ್ದಾರೆ seal ಕೊಟ್ಟು seal ಹಾಕಿದ್ದಾರೆ ನೋಡಿ. Already served in 20 itself.
That's, my lords, my lords, I have not stated that they have not served. I have received. I'm
That
not
office
making that
objection is, we
submission.
have to file the
No, no.
acknowledgement in the office.
ಅಲ್ಲ ಮಾಡಿ ನೋಡಿ seal ಹೊಡೆದಿದ್ದಾರೆ
Sir, ಅದೇ acknowledgement.
ಅಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ this copy of the acknowledgement.
He is accepting, I am recording it. What is the difficulty? I'm not able to understand. Recording that the office objection is no more and he has already. The land counsel for the petition submits that the second petitioner is no more.
No more.
And he'll come up with an application to bring the LRs on record.
Please,
This
ma'am.
is matter on 4th of March.
Please, my lord.
Cell number
Yes.
15.
Grateful.
Cell number 15. VK Chandrasekhar for petitioner. DN Vishwanath.
Carry out the amendment. The respond number 1 dead. These LRs are already in record. I should only round up.
That's what you do it. Amendment of the cause title
I
as
do
per
it.
the order.
I do it.
This-
Order dated 15/2/2024.
True, my lord.
Non-amendment of the petition shall do the
Even I
needful.
have
The
no voice.
petitioner shall do the needful within 2 days.
Even
Yes.
I have no voice.
2 days.
I'm
Huh?
sorry, I have no voice. To do justice to the party, I am seeking
That's what I
permission
said, do it. No,
to do it. I do it.
yes,
Days.
the petitioner shall do the needful within 2 days. Yes,
Cell
this
number
is
16.
matter thereafter. Yes, 16.
Rajgopal Naidu. Cell number 16, Rajgopal Naidu for petitioner.
Notice to respondent 4 returned as unclaimed amounts to deemed service of notice. In respect of R3 to R5, the process shall be paid within a week or else the appeal against R3 and R5 stand dismissed.
Cell number 17, Nataraj Ballal for petitioner.
Petition. Weeks time.
A week's time to do the needful, same default order. 18,
18, Vinod Reddy.
In this case, ma'am. Kindly 1 week time may be granted to do.
a week's time default order. 19,
Cell number 19.
Stabilize.
Sachin
I represent the respondent number 1.
As for the appellants, I may be permitted to file a paper publication minutes against
where is that?
R7 and R9 minutes.
Where is that?
May I make a submission, my lords? This is arising out of an order in the FTP proceedings, where a stranger to the proceedings files an application for impleading. That application has been dismissed by the court below, holding that they have no right to come in the FDP.
Interim order is there.
Interim order is there. The further proceedings is stayed in the FDP. Let the FDP go on, my lords, because the petitioner will not have any right over the property which is a subject matter of FDP. He has not challenged the appeal.
Let your senior come and argue, or you only argue.
My lords, it may be 1 week time may be granted, my lords. We have filed an
This is matter on Friday. We will hear you, and if there is any substance, then we will see about the notices and all.
obliged.
Yes.
Cell number
My lord,
5.
my lord, apologies, my lord. Serial number 14, my lord, interim order is there. It may be extended, my lord.
Look at it, if interim order is there.
14, my lord.
Yes.
Grateful, my lord.
20,
Cell number 20.
Interim orders maybe.
this also 19 also interim order till then.
Cell
Yes,
number
20.
20. Hanuman Rayappa K.
A memo is filed seeking dispensation of notice to R4. Accordingly, the memo is taken on record and our notice to R4 is dispensed with at the risk of appellant. The amendment shall be carried within a week or else the petition shall stand dismissed without further reference to the court.
Cell number
Yes.
21. Ramchandra Iyer,
Representing the appellant in this case, Your Lordship. The court has sought for some time, for extension of time. The matter is posted for orders on the 11th of February, Your Lordship.
Letter is addressed by the lineage judge.
It's posted on the 11th, Your Lordship, for orders.
Speaking. Extension of time. As per the order, this court had passed an order. As directed to dispose of the IA within 2 months from the date the assets and liabilities are filed. The parties are just like that, asking for the adjournments.
Your Lordship, not the appellant, Your Lordship, because the appellant, in fact, has to
On
deposit
7/1/2025 and 8/1/2025, both sought adjournment for hearing. Hence, matter was adjourned. The parties just like that cannot seek adjournment, and the court also shall not grant unnecessary adjournments. Finally, 15 days time is granted to dispose of the IA. Yes, next.
Serial number 22. 22 urgent, 23 urgent, serial number 24 urgent, 25. Nishit Kumar Shetty for petitioner.
This is arrangement of execution petition, Lord. The
Who appears for the respondent?
Respondent Pushpa.
You have an interim order in this?
please, my lord.
Rani.
This is matter on 18th of March. No representation for the respondents. Interim order earlier granted is extended till then 26.
Serial number 26. Mithun SK for petitioner. Abhinav R for respondent.
For the petition, my lord, the amendment application which was filed,
You have an interim order in this?
there's no entry matter, my lord. But my lord, it's 2018 matter, my lord, that's seeking adjournment on every occasion, my lord.
No representation for the respondent. Counsel for the petitioner is present. This is matter as part heard tomorrow.
Serial number 27.
For the respondent.
27.
Submission. Senior Counsellor Mr. Sam Sundar is engaged.
Huh?
Senior Counsellor Mr. Sham Sundar is being engaged in this matter. So kindly request you to pass it over to post lunch.
Pass over.
Please.
Okay, pass over.
Number 28.
28.
Serial number 28.
29.
29. Serial number 29. Puneet K.
No representation. List this matter on 15th of April.
Serial number 30. Serial number 30.
Respondent.
Prashant.
Counsel for the respondent is present. No representation for the petitioner. In these kind of matters, don't extend the interim order where there is no representation. List this matter on 25th of March.
Serial number 31. D. Prabhakar for petitioner.
Counsel for the respondent is present. No representation for the petitioner. This is matter on 26th of March. Let them be there. Yes, next 32.
Serial number 32. Gurrajar is urgent.
Appear for the petitioner, my lord. This is
Renta DV Gowda.
Huh?
my lord.
33. Serial number 33.
32, not 33.
26 3.
Huh? 32 is called now. Vishnu, it is 32. Yes.
Serial number 32.
I appear for the
Gurrajar.
petitioner, my lord. This is the plaintiff.
You're ready?
Yes, ma'am.
Then counsel for the petition is present. No representation for the respondent. List this matter as part heard tomorrow. Interim order is there.
Please, ma'am.
Extend it till tomorrow. Yes. 33.
33. Gautam Chand.
No representation on behalf of both the parties. Then counsel the respondent is present. No representation for the petition. List this matter on 8th of April. Don't extend interim order.
Serial number 34. Amresh A. Angry for petitioner. AG Nagaraj.
No representation on behalf of both the parties. List on 23rd of April.
Serial number 35 disport, 36, R.B. Sadashivappa for petitioner. Sidmallappa for
Counsel for the petition is present. No representation for the respondent. List this matter as part heard day after tomorrow.
serial number 37. Vardhaman Gunjal for petitioner.
No representation for both the parties. List this matter on 28th of April.
Serial number 38. D. Prabhakar.
No representation for the petitioner. List this matter on 24th of April. Don't extend the interim order.
39. Chidambar GS. Serial number 39. Chidambar.
Same order, no representation on behalf of both the parties. List this matter on 9th of June. Don't extend the interim order.
Serial number 40.
40 is adjourned.
40 that the other side not informed that way.
The 40, at the request of learned counsel for the, no representation for the petitioner, at the request of learned counsel for the respondent, list this matter on 28th of April. Don't extend the interim order.
Serial number 41 dispose, 42. Sampath A for petitioner.
No representation on behalf of both the parties. List this matter on 10th of June, not to extend the interim order.
Serial number 43, Sarvana S.
That is adjourned.
That is also not.
Your Lordship, for the respondent, Your Lordship, I deeply apologize for the confusion in the morning, Your Lordship. I sought for a week's accommodation. We're ready in this matter. It may be taken up on Friday, Your Lordship,
You
this Friday.
represent whom?
For the respondent, Your Lordship.
KJ Kamath.
Please, Your Lordship.
At the request of learned counsel for the respondent in 43.
Please.
Is this matter on any interim order in this?
Yes, Your Lordship, there's an interim order.
List this matter on 12th of March.
Your Lordship, a shorter accommodation may be given, Your Lordship. I seek for a shorter accommodation. We're ready in this matter, Your Lordship.
12th of February.
Please, please, grateful.
Yes,
Serial number 44, Archana Murthy for petitioner.
No representation on behalf of both the parties.
Petitioner Lordship.
Yes, you're ready? Huh?
Tomorrow or day after tomorrow.
No representation at the request of learned counsel for the petitioner. List this matter day after tomorrow. As part heard.
Yes.
45,
This is adjourned.
45, 46 adjourned. Serial number 47, Prasanna M. Patil for petitioner. 47.
No representation. List this matter on 19th of March. Don't extend the interim order.
Serial number 48, Ganapati Bhatt.
No representation. On behalf of the petitioner. List this matter on 25th of April. Don't extend the interim order.
Serial number 49, Sachin B.S. for petitioner. R. Subramanya for R2.
Same order, no representation. On behalf of both the parties, list this matter on 16th of April.
Serial
Yes,
number 50, Raghuram Kadambi for petitioner.
My lords, I appear for serial number 50. Appear for the respondent in serial number 50, my lords.
yes.
Respondent number 58.
We're being led by a senior counsel. He's not available today.
Tomorrow,
1 week's time, my lords, I have to.
a week's time is not possible, either Friday or a long day.
Um,
Thursday will take, huh? If it is long day, no interim order will be extended.
Please, on Friday, my lords,
Yes, list this matter on Friday.
interim order may be extended.
Interim order is extended till then.
Serial number 51, Asmit Egda HS for petitioner. Anu Parnali for respondent. 51,
No representation on behalf of both the parties. List this matter on 26th of March. Yes. Any matter? Item? 30? Ready? What happened to this 37? 37 day after tomorrow, at the request of learned counsel for the petitioner, 37. Yes. Interim order is there, extend then. Yes. 49? No, ready. This also day after tomorrow, 49, at the request of Land Council the petition. Yes,
My lord, serial number 10, my lord, unfortunately, I'm not extending interim order, my lord. Yes, we
10,
can interim order.
if it is the interim order extend, yes, next,
Plus 29, my lord, we are ready, my lord, 29.
29.
Please, my lord, for petitioners, my lord, we are ready.
Who appears for the respondent?
Responding, my lord, my Lanesh senior, my lord, Vishwanath sir, affairs, my lord, I'll just,
Ten.
Lord's permit, my lord, it could pass or I'll inform them, my lord. Or say, or day after tomorrow,
All the
Lord's,
matters are now the board is complete.
please, my lord.
Appeal for that.
No, my lord, Lordship may have it day after tomorrow.
Day after
Please,
tomorrow.
for
Day after
that
tomorrow.
29.
29.
Please,
29 day after
please,
tomorrow.
and 42, I was ready, my lord. Government is the opposite, my lord. 42.
42 tomorrow,
Please,
42.
tomorrow, interim order is there extend, yes,
please,
42.
oblige.
Serial number 18, madam.
40? Uh.
48 it is, sir. 25-4. Urgently 25-4.
Interim order maybe. 48 interim order extend, yes. No, interim order is there, long date will not be given. 48, list is matter on Thursday, interim order earlier granted is. You- No, please be there, no, like, we'll have it on Thursday, give with the, any connected matter is there, because I have to see, we can't, I'm only extending the matters where there is no representation. Extension or interim order, if it's extended, will not. Yes, Thursday. Next,
Interim order.
interim order extended till Thursday.
My lord, serial number 18, my lord. Serial number 18. Appearing
Take
for.
it long back over,
No, my lord, interim order may be extended.
what happened to that?
1 week time is granted.
Stands dismissed.
Yes, interim order, if it is there extended, then
Much obliged.
I'm sorry, my lord, 29 interim order may be extended.
which
my lord.
one?
29, my lord, for
29 also extend the interim order.
Yeah.
I'll permit the petition, but from that RFP is pending. Therefore, sir, have you, in 10 days, have you granted, then I.
You know that 48, same date, give that April, March date, give a police's matter on 4th of March. 48. Interim order is extended till then, if it is there, look at it. Yes. So what are the, how many are the passwords, matter? What are the numbers?
Passover matter, serial number 5.
5 and?
5 and serial number
5 post,
8.
5 post tomorrow,
5 post.
tomorrow,
Yes.
and then the senior council matter.
8.
No, senior council matter. Call them and whichever is convenient tomorrow, day after tomorrow, give the date. So that I can do some work.
Number 27.
Whatever is the date they want, let them come and give the date.
Yeah.
Do that? Give this. As per the. Earlier. Any matter? Serial number? 49. Somebody has asked for it. Friday. 49, when is it coming? 5th. 5th it's coming. Interim order is extended? Yes.
ಮೆಮೋ ಕೇಳ್ತೀನಿ ನಮ್ಮ ಬರ್ಬೇಕು. ಇವತ್ತು ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಳಿಸ್ತೀವಿ, ಹೇಳ್ತೀನಿ. ಅಲ್ಲಪ್ಪ 15, 49. 49
ಮೇಡಮ್ ಡೇಟ್ ಗಳು
ಡೇಟ್ ಎಲ್ಲ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿಪ್ಪ.
27 ಅಂತ ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದ ಅದು ಯಾವ ಡೇಟ್ ಹೇಳಿ ಈ ವೀಕಲ್ಲಿ? 27 your madam told that to give some date to them. because of that one day matter ಅದು
26 ಅಲ್ಲಿ
ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು
petitioner.
ಅದಕ್ಕೆ ವಿಚ್ ಡೇಟ್ ಯು ವಾಂಟ್ ಯು ಗಿವ್ ದಟ್ ಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ ಬೇಗ ಹೇಳಿ.
30
ನೀವೇ
Court officer? Court officer?
ಹೇಳಿ ಮೇಡಮ್. ಹಲೋ ಮೇಡಮ್ ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಏನಾಯ್ತು ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. 40 28/4 ಹೋಗಿದೆ.
ಓಕೆ ಮೇಡಮ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 40 28/4 ಗೊತ್ತಾ ಮೇಡಮ್?
ಎಸ್ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 43 ನಲ್ಲಿ. ಹಲೋ
ಹೇಳಿ ಮೇಡಮ್.
43 ನಲ್ಲಿ ಡೇಟ್ 12th Feb ಅಂತ ಹಾಕಿದಾರೆ ಅವರು ಸಾಹೇಬ್ರವರು. ಮೇಡಮ್ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿ ಚೇಂಜ್ ಮಾಡ್ಬೋದಾ ಡೇಟ್?
ಇಲ್ಲ ಅದು ಆಲ್ರೆಡಿ ಮೆನ್ಷನ್ ಮಾಡಾಯ್ತು.
ಹೌದಾ?
ಲಿಸ್ಟೇ ಕ್ಲೋಸ್ ಆಯ್ತು.
ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಯ್ತಾ? ಓಕೆ.
ಮಧ್ಯಾಹ್ನ ಬರಲ್ಲ.
ಓಹೋ ಓಕೆ ಮೇಡಮ್, ಆಯ್ತು.
ಓಕೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಅದೇ